Welcome to Benchmark TV's production today, where we're joined by an associate solicitor from my own firm, Blackstone Legal Costing. Before we get on to introducing Dipal Prasad, just a little bit about myself. I've been a partner at Blackstone Legal Costing for about 4 years, and I'm thrilled to be back at Benchmark TV to interview one of our very own, an associate solicitor working out of our Sydney office, who's recently prepared and circulated a fantastic blog looking at a recent case in relation to the question of indemnity costs. And so, Dipal Prasad, welcome to Benchmark TV. It's great to have you here.
Thank you.
MCG Group Pty Ltd and Fortress Pty Ltd. A matter that was heard in the federal court as recently, in fact the judgment as recent as April of 2017. So perhaps you can give us a little bit of background around the case before we look at some of the key issues arising from the judgment.
Sure. This case is important to all lawyers as it focuses on two of the few circumstances due to which a court can award indemnity costs, that being when the other party willfully disregards facts or the other party does not accept a favourable offer, a Calderbank offer or an offer of compromise. Indemnity costs often being, of course, being the highest form of cost order that is recoverable on a party-party basis. So the winning party can recover the majority of its costs from the other side for having to pursue or defend a litigation.
And of course, costs on the indemnity basis are permitted really in their entirety unless unreasonable in amount or unreasonably incurred. And so that's a very high standard.
Yes.
What's your experience with respect to costs perhaps on the ordinary basis inter partes as opposed to an indemnity basis in terms of cost recovery out of a matter?
Majority of the cases that we get, the costs are awarded on a party-in-party basis or an ordinary basis. For those cases, costs are usually recovered between 70 to 80% of the actual costs that were incurred for the party running a matter. Whereas an indemnity cost, it could be from 80 to up to even 90% of the cost of running a case. So the difference is quite paramount.
Yes, interesting. In fact, I think some of the matters that we've dealt with, we've seen as much as a sort of a 98% return on costs being sought on the indemnity basis. And so it's a very useful tool if available to a client, and practitioners should really be aware of the requirements in order to achieve an order on the indemnity basis. And so perhaps we can just talk a little bit in general terms around the circumstances that will perhaps enliven an indemnity costs order.
There is abundant case law when, as a result of which an indemnity cost order can be enlivened. This includes hopeless cases, abusive process, unreasonable conduct, relevant delinquency during the proceedings, unreasonable conduct, even fraud or misconduct, or when Calderbank offers or offers of compromise are made. Out of these, it is stated in the case of Nair Smith and Perisher Blue that the most common basis for seeking an indemnity cost order is when Calderbank offers or offers of compromise are made.
So I guess in short, an indemnity cost order is enlivened really where one party has done the wrong thing.
That's correct.
Either because of something fraudulent in perhaps the most severe case, or even where they've simply failed to accept a reasonable Calderbank offer. So turning now to the MCG Group case itself, what's most important about this matter?
The decision in MCG Group that we're concerned with today arises out of a hearing on costs. The principal judgment concerned a contractual dispute between two brothers, Bill McDonald and Paul McDonald. Bill McDonald had control over MCG Group Proprietary Limited, and Paul McDonald had control over Fortress Proprietary Limited. Bill McDonald Paul McDonald alleged that there was no contract between him and MCG Group, that MCG Group would that Paul McDonald had to refund MCG Group the monies that MCG Group had paid to the ATO for a liability, for a tax liability of Fortress Resources Proprietary Limited, another entity owned by Paul McDonald. So there was a question of whether either of the parties had entered into the agreement. Ultimately, orders were made against Fortress Proprietary Limited and Paul McDonald and in favour of MCG Group in the amount of about $800,422 with interest of around about $94,000. This amount would be relevant when we discuss Culture Bank offers and its relevance to obtaining an indemnity cost order.
Interesting. So just to clarify, there was an order against both the company and the individual in relation to this matter?
Yes, so there were two respondents, Fortress Proprietary Limited and Paul McDonald.
Yes. And so would it be fair to say that a special circumstance is required to allow costs to be awarded on the indemnity basis?
Yes, so judges have a wide discretion with respect to when to award indemnity costs. Various case law suggests that special circumstances are required to exist to enliven an indemnity cost order. In the MCG Group case itself, Justice Greenwood refers to the case of Intertan and DSE Holdings. In the Intertan case, 9 special circumstances were identified. These are the bringing of an application that is high-handed.
High-handed, that's an interesting one. So what do you take from that?
That would probably mean any application that, for example, is claiming 10 million in costs, but it's actually worth 1 million or even less. So it just requires the other side to prepare a very strong defence when it really wasn't necessary.
Sure, when there's such a large sum at stake and unnecessarily so.
Sure, yes.
And some of the other circumstances?
So an application that has no chance of success, an application that is hopeless.
Those two sound very similar, but I suppose they themselves rely on other case law and precedents? Definitely,
the application that has no chance of success relies on the case of it comes from the case of Fountain Selected Meats Sales Proprietary Limited, and the precedent that where an application is hopeless comes from the case of J Corp Proprietary Limited and Australian Builders Labourers Federation Union of Workers, Western Australia branch.
Interesting, and I think that's of interest to our viewers who perhaps may be thinking, this particular matter I'm looking at the moment seems like a very doubtful and hopeless case. Well, perhaps you should give some consideration to some of those precedents. And perhaps we can move on to some of the other circumstances.
Again, an application that is unnecessary, an application that is brought and prosecuted not for the bona fide purpose of protecting and enforcing a legal right, but to achieve an ulterior motive or for an extraneous purpose. Another circumstance would be when an application is commenced in willful disregard of known facts or contrary to well-established law.
That's an interesting one.
This is the one that we will be discussing in the MCG Group case.
Indeed, and we'll have a look at that in closer detail. And some of the other circumstances, sure. I think there were 9 listed in total.
Yeah, so there's 3 more. An application where there has been some relevant delinquency on the part of the unsuccessful party, where the justice of the case warrants such an order, and where there are some special or unusual features in a case to justify the court exercising its discretion in this way.
And that's an interesting point, the last one, because it really brings into play a range of circumstances which will bear on enlivening the availability of an indemnity costs order. It comes down to the circumstances and the court's discretion, doesn't it?
It definitely does. So courts definitely have a wide discretion in awarding indemnity costs. Solicitors should definitely keep this in mind when drafting orders for costs. Justice Greenwood, in the case of MCG Group, specifically stated that whilst these list or categories of special circumstances can be considered or are to be considered by courts, the facts and circumstances of each case is what would be considered or will be the most important consideration.
And that's an interesting point to make, because there's probably only one really, if you like, certain approach with respect to obtaining such an order, given the wide range of circumstances and the wide discretion held by the court. And that really comes down to a call-to-bank offer. And that's going to tie into, I suppose, the second part of our discussion around MCG Group.
Yes.
So just to clarify, special circumstances that have been laid out, you've mentioned 9 of them. They can assist lawyers, can't they, to obtain those orders?
Certainly, they are precedent cases that lawyers can use in their submissions on costs to assist them in obtaining an indemnity cost order.
So let's have a look at the circumstances in the MCG Group case.
Yes.
Have a look at this in more detail.
Sure. So the one circumstance highlighted by the MCG Group case was the scenario where the applicant said that the other party had engaged in willful disregard of facts. So particularly during the course of the trial, when Mr. Paul McDonald, the second respondent, was being questioned, the court found that he had answered several questions in an obfuscated manner, particularly as in relation to whether or not he had entered into an agreement with his brother, which was one of the main issue in the proceedings. Yet, Justice Greenwood considered the exception highlighted in the case of Fountain Selected Meats Sales Proprietary Limited and International Produce Merchants Proprietary Limited that says indemnity costs will be justified where someone commences an action in willful disregard of known facts or contrary to well-established law. However, in this case, Justice Greenwood held that the obfuscation by the second respondent was not alone sufficient to warrant an indemnity cost order. The judge goes on to specifically state, although Mr. Paul McDonald clearly engaged in obfuscation in answering a number of questions in the course of the proceedings, I'm not satisfied that that by itself demonstrates that the respondent engaged in willful disregard of the primary facts in the course of the trial. I'm therefore not satisfied that special circumstances required to justify an order for indemnity costs of the whole proceedings subsisted in this case.
Okay, so there needed to be more, not simply willful obfuscation and perhaps being evasive in answering. I haven't seen this transcript, but clearly the judgment comes down with the view that despite some of this being present in the evidence, it didn't justify on its own merits the award of an indemnity costs order.
Yes, the judge held that obfuscation did not even amount to a willful disregard of facts. So the special circumstance that would enliven an indemnity cost order did not even exist in this case. In support of His Honour's argument, Justice Greenwood quoted the case of Christophedelis and Drillick. This was a 2000 Federal Court of Australia case in which it was found that an adverse credit finding did not lead to, it will not in itself lead to an indemnity cost order.
Interesting. So in that particular case, I gather some evidence was given that turned out to be incorrect.
Yeah, so in the Christophedelis case is another case that focuses on the principles of indemnity costs. In this case, the applicants alleged that the respondents, who are a real estate company, the real estate agents, had made certain assertions as to the size of a property and the divisibility of a property to prospective purchasers. However, Justice Einfeld in this case could not find any sufficient corroborative evidence to support the alleged assertions that the real estate agents had made. As a result, the applicant's application was dismissed, and interestingly, an order for indemnity costs was made. However, Justice Einfeld went on to say that the at paragraph 29, Justice Einfeld specifically stated that such an adverse credibility finding would not by itself or in the ordinary course of events justify an order for indemnity costs. However, the fact that these proceedings were destined to fail from the start, regardless of the applicants' credibility as witnesses, suggests that this case is not the class contended for by the applicants, and as such, it weighs heavily in support of the court making an order sought by the respondents.
The indemnity order.
That's it.
So I suppose the take-home message from that is don't rely on one particular circumstance if you're building a case in support of
Yes.
An indemnity costs order. You need to try and pull a few different facets together to support your view that an indemnity order should be made. But ultimately, as I said earlier, the offer of compromise provides a lot more certainty around the enlivening of such an order. So in this particular matter, MCG Group, that was the second plank, if you like, of the argument in support of an order for the indemnity costs. How did the court deal with that, and perhaps just look at some of the detail around the argument raised in support of an order on that basis?
In the MCG Group case, MCG Group contended that if it did not get indemnity costs for the full proceedings, it should be awarded indemnity costs from 30th November 2015, which was the day it had made a Calder Bank offer to the other party or the other side. However, the court did not make an indemnity costs order, and the reasoning is quite interesting because the MCG Group had made an offer of $750,000 to settle the dispute, and the ultimate judgment in the matter was around about $800,000 plus interest. So
it seems to me on that basis, the offer was bettered as a result of the judgment. But there's a little bit more to it, isn't there?
Certainly. On the face of it, it looks like the applicant should definitely have been awarded indemnity costs. The respondents would have been better off by $135,000 had they accepted the offer on 30th November or around about that time.
Not to mention the additional costs they've incurred in running the matter themselves.
Sure.
To the hearing.
Yeah, so that's additional cost there. There were various issues or reasons why indemnity cost orders weren't awarded. One issue was that the applicants had inadvertently claimed a lower amount in its statement of claim for damages, so in the order of around about $600,000.
Well, that's an interesting point.
And this was due to a calculation error.
And so they amended their pleading, I understand, later in the proceedings.
Sure. They amended it in around about June 2016, but this was well after the offer was made in November 2015. Yes. So what the court decided was they would look at the damages as claimed in the statement of claim to consider whether or not the respondents were reasonable in rejecting the Calder Bank offer.
Because that was the relevant number
yes.
with respect to the offer when they're considering the offer.
Yes, that's correct. Well, that's what the respondents knew the damages claim was at that point of time. In doing its calculations, the court found that after adding interest of around about $59,000 and estimated costs of around about $90,000 during the period when the Calder Bank offer was made, the amount of claim inclusive of interest and costs would be around about $823,000. So even by this calculation, the respondents would have been better off by around about $74,000 had they accepted the Calder Bank offer at that point of time.
So it begs the question, doesn't it? why why did the court find that the call to bank offer did not enliven an order for indemnity costs?
Sure. This was the most interesting part. The Calder Bank offer that was made on 30th November 2015 was only open until 1 December 2015, actually 10 a.m. on 1 December 2015.
Oh, a matter of hours.
Yes. So the court ultimately found that regardless of whether or not the respondents would have been better off by accepting the Calder Bank offer, they had a very short window of time frame to consider the offer. So it was unreasonable. That time frame was unreasonable, and that was the reason why an indemnity cost order was not made. The judge specifically quoted, the respondents had no reasonable opportunity to assess the costs. They probably could have calculated interest from the date of filing to 30th November 2015 on an amount of $673,000 for themselves. However, I'm not satisfied that the respondents acted unreasonably in not accepting the offer as made. The rule to remember here is that time limits are important when making offers to settle. When you make a Calder Bank offer, give the other party sufficient time to consider that offer. That would assist you in getting an indemnity cost order, pretty much.
So the trick is there to consider the amount of time available to the other side to give it some appropriate consideration, and that goes to the level of genuinosity.
Yes.
Of the offer, if I can coin a phrase.
Yes.
So surely there are some circumstances in which an offer of as little as 1 day in terms of time for acceptance would be considered reasonable.
Definitely. It always depends on the facts and circumstances of the case. If, for example, if an offer is made on the day of the hearing or the day before the hearing, such offers may be considered reasonable. Similarly, it would be reasonable to reject an offer made too early in the proceedings, because that doesn't give the other party enough time to consider damages that are...
Or even the merit of the case.
Yes, that's right. We see this a lot of the times in personal injury matters. And rejection of Calder Bank offers that are conditional on a party or a third party performing an action is likely to be considered reasonable.
Interesting. And I think some of the experience I've had, I've seen Calder Bank offers considered unreasonable because they seek an outcome that wasn't actually sought in the initial pleading itself. And so there are a range of matters, aren't there, which have a bearing on whether or not a Calder Bank offer will be considered genuine and reasonable.
Yes.
And MCG Group has certainly identified this as not being reasonable given the time frame during which the other party had to consider the merits of it.
Yeah.
I would have thought a 24-hour time frame to consider costs anywhere around $100,000 incurred to that point probably isn't sufficient, almost universally.
Yeah. Yes. In this, again, it falls on the facts and circumstances of the case. In this case, that was certainly the case. That's what Justice Greenwood found, that there was a very short window of time frame to consider the cost that would have been incurred by that date.
Interesting. So perhaps just moving on to another and final sort of facet of the MCG Group case. An award was ultimately made, wasn't it, with respect to the parties' costs based on the ordinary basis?
Yes.
The paying party raised a further argument as to why they believed that order itself should be limited and certain costs should be carved out of that order.
That's correct.
Let's have a look at that part of the case.
Yes. So the applicant had amended its statement of claim on the first day of trial to discontinue a claim for damages under Section 236 of the Competition and Consumer Law. The respondents argued or sought to be compensated for costs thrown away as a result of the amendment, because they may have undertaken several work to defend that aspect of the claim. In the alternative, the respondents sought to not be liable for costs pertaining to that amendment. Justice Greenwood said that he accepts that the respondents were put to some expense in preparing to defend this aspect of the claim, which was ultimately not pressed. However, quote, "I'm not satisfied that any separate order ought to be made concerning these costs. The applicants were successful in the proceedings overall and ought to have their costs without any set-off or cross-order in relation to an aspect of the earlier pleading."
Interesting. So the take-home point from that is that a set-off or a cross-order with respect to costs is actually quite unlikely, isn't it? In circumstances in which a particular part of a proceeding has it been abandoned or has lacked merit.
That does seem to be the rationale in the MCG Group case. It might be noteworthy that this was a sort of a minor part of the claim, so that may have led to this order, led to no cross-order being made. Ultimately, the respondents were still ordered to pay costs, but to pay costs on an ordinary basis,
Yes.
rather than an indemnity basis.
And I have to say, from a cost lawyer's point of view, it's a bit of a nightmare scenario, having to carve out costs that maybe relate to one issue or another. Many times we see affidavits that deal with a number of issues, and finding the right proportion perhaps of an attendance that maybe relates to a number of facets of a pleading can be quite a difficult and somewhat subjective task, can't it?
That's very correct. It becomes a nightmare, just carving out costs. Of course, we do that when such orders are made. It adds to the costs of doing the work.
Indeed, it makes it a more difficult and onerous task to recover those costs. So it's always best to get an all-encompassing order.
That's correct.
With respect to your costs, and certainly avoid any carve-out. And the courts appear to be adopting the approach that they're very reluctant to carve out costs in relation to failed issues, and certainly been the case for many years. So what would you say some of the main points are that arise from the MCG Group case for practitioners to take home?
There are quite a few lessons to be learned from the MCG Group case. One would be that costs are often awarded, generally awarded to the successful party on an ordinary basis, unless there are special circumstances justifying any other cost order, such as an indemnity cost order. Also, whilst case law helps determine what special circumstances give rise to an indemnity cost order, such an order usually depends on the facts and circumstances of each case. Also, a party answering questions in an obfuscated manner during the course of the trial does not alone demonstrate a willful disregard of the primary facts in the course of the trial. Therefore, such behaviour alone does not amount to a special circumstances that would enliven an indemnity cost order. In addition to special circumstances, indemnity cost orders are also awarded when Calder Bank offers have been made and a favourable offer has been rejected by the other party. However, time limits are very important when putting forward offers to settle claim. This is probably one of the most important take-home message for solicitors. Focus on the time limit that you're providing when putting forward Calder Bank offers, as this may cost you an order on for an indemnity cost.
Really, for an offer to be considered, there needs to be appropriate time, and the offer needs to be, of course, genuine.
We further learn from this case that errors in the amount claimed in a pleading can cost a party an indemnity cost order, which happened in this case, and which is a shame. And further, that it is rare for set-off orders or cross orders to be made for minor costs thrown away in a proceeding.
Fantastic. Well, it's been great to discuss with you this case today, Dipple. And I'm looking forward to seeing how the case law develops in this area in the months and years to come. Certainly cost law is becoming more and more complex, and there's lots of nuances to be familiar with. Thanks for joining us today.
Thank you.